go.
Hi, everyone. Welcome to this CLE that is being sponsored by the Sustainable Economies Law Center. My name is Daniel Irvin. I'm an associate at Morrison Foerster, and I work quite a bit with hybrid structures, which we'll talk about in a second, what that is. But if you're in here for a training on hybrid nonprofit for-profit structures, you're in the right place. I'll pass it to my colleague, Michael.
Hey, everybody. Michael Santos. I'm a partner at Morrison and Foerster. Likewise, I work in our impact investing group, and we deal a lot with hybrid structures for aggregating capital, deploying capital, and embedding mission into governance. So looking forward to discussing with everyone today.
Our bios again. Already saw that. So we'll start out. What is a hybrid tandem structure? And I believe in terms of questions, I think we'll have time for questions at the end, but certainly feel free to drop things in the chat, and I think folks on the panel can help review those as they come in. But what is a hybrid/tandem structure? So this can describe a wide variety of relationships. What we're going to talk about today and what we generally refer to when we talk about hybrid structures are relationships via equity ownership, funding, or just contracts between a nonprofit and a for-profit entity. And we kind of bucket these into 5 general types. The first is just a simple contractual relationship between a for-profit entity and a nonprofit entity. The second is when a nonprofit makes a investment into a for-profit entity as a minority owner. The third is a nonprofit forms a for-profit and it's its wholly owned subsidiary. The fourth is a nonprofit where there is a for-profit that is its member. And then the fifth is nonprofits making investments into for-profit investment funds, like impact investing funds. So before we go into those structures, we should first make sure we're on the same page. What is a nonprofit and what is a for-profit?
Yeah, so we'll go over first just kind of some basic background on nonprofit organizations, and there's a wide variety of these, but some of the ones that we see most frequently in the types of structures that we work with. At a high level, a nonprofit organization it's a type of corporation, which means it's a function of state law, and similar to a for-profit corporation, it is formed in an applicable state. So every state has its own types of nonprofits. In the for-profit world, we typically counsel companies and startups to form in the state of Delaware. There's a particular reason for that, one of which is that it's the most kind of developed corporate law. For nonprofits, that's not always the case. It's a little bit more of a function of where you're going to operate. And so if you're a nonprofit that is based in California or has significant operations in California, it might make more sense to form the nonprofit in California or pick your state. There are a variety, as I mentioned, of types of nonprofits. Here, a couple examples in the state of California. You have a public benefit corporation, which is, I would say, the more kind of common and standard type of nonprofit where it is formed for a public good. You also have mutual benefit corporations, which kind of per the name are formed more for kind of a membership association versus the broader public good. And then you also have religious nonprofits. Wide range. We will typically be dealing with charitable or public purpose type nonprofits, which we will get into our public charities and private foundations. Similar to for-profits, again, the incorporation process, you're going to have your articles of incorporation or certificate of formation, whatever the nomenclature. That's a document that gets filed with the Secretary of State. It's a public filing document, and that forms and creates your entity. Within that document, you will have a charitable or public purpose, which is distinct from a for-profit. Typically, a for-profit is formed and operated for any legal purpose. We will get into some of the new corporate forms that do have a public benefit, but historically, it's been for any legal purpose. You appoint your board, you adopt bylaws, you appoint officers, you file for an EIN and get a bank account. A lot of the formation process is similar to a nonprofit. One unique aspect is you do not have stockholders in a nonprofit, so they are not owners in the same sense that there are for for-profit corporations. And then tax exemption. A big reason people form nonprofits is for the tax exempt purpose. It is not a requirement to be a nonprofit corporation, but if you are seeking tax exemption, there's a filing at the federal level with the IRS and then a filing at the state level where you are incorporated.
And one thing that'll be relevant later in the presentation when we talk about interested and disinterested directors when you're doing a hybrid structure is California. There is this rule that 51% of a nonprofit's board cannot be employees of a nonprofit or paid by it. They have to be independent and disinterested.
So I mentioned there's a wide variety of nonprofit organizations. The one that we see most frequently are 501c3 organizations, which are either public charities or private foundations. And we'll get into the distinctions between those. But as you can see in the last bullet of this slide, there are a lot of different tax exempt organizations under 501c of the tax code. There are social welfare organizations, which people may be aware from super PACs. There are 501c5, which are labor unions, and a variety of others. But we most frequently are working with 501c3 nonprofits. As alluded to, right, tax exemption, why often you are seeking to form a nonprofit is the tax deduction for donations and tax exemption for income tax. This is both at the federal and state level. There are specific requirements for meeting your exempt purpose, which is listed out here on the slide. Historically, the filing with the IRS, which is the Form 1023, anywhere from 7 to 12 months. Currently, it's a lot longer processing times. We're seeing upwards of 24 months for getting tax exemption through. So it's a much longer delay. The nice aspect is your tax exemption is retroactive to the date of filing. So if you don't get that for a year or two, it will be retroactive for the tax exempt purpose.
So as Michael alluded to, when we're talking about 501c3s, which is what we most often see in hybrid structures, there's two types of 501c3s. The first is what's called a public charity, and the second is a private foundation. And the distinction between the two is that the public charities are viewed by the IRS as having kind of broad public support, versus private foundations are usually set up by a single donor or small group of donors. And so the nuts and bolts of that is the IRS has what's called the public support test, which the Law Center also has an online resource describing this test. But at least a third of the funding from for the nonprofit, for the 501c3, must be from the general public, which basically means people who are not 2% donors to the organization, people who are not donating at least 2% of the donations grants. There's a alternative test that's more of like a facts and circumstances test if you don't meet the public support test, but that's typically you're trying to meet that public support test. And this is going to be most common for organizations that are like operating and doing stuff like the American Cancer Society, World Wildlife Federation, anyone that sort of collects donations broadly and then is doing, direct charitable services, is usually this category. Um, Public charity still, so generally people want to be a public charity versus a private foundation if they can, because there are less restrictions on the activities of public charities. But there are still IRS rules and guidelines. And this includes no private inurement, which means that the earnings of the 501c3 do not inure to the benefit of any private shareholder or individual. And so basically the earnings of the nonprofit can't flow towards the CEO, the executive director, and their, the other senior executives, and there are some of the penalties are in the parentheses there. No private benefit, similar to private inurement. The nonprofit can't operate for the private benefit. Private benefit is a little broader in terms of you can have impermissible private benefit for the founder's family, other controlling parties, or even non-controlling parties too. Just other third parties. The public charity has to be operated for exempt purpose, and public charities, 501c3s can't engage in lobbying. They can do a little bit of lobbying, like self-defense. So, universities will sometimes lobby on behalf of like protecting their direct interests, but they can't be political organizations.
One just note on the private inurement point, which is, as Dan alluded to, benefiting insiders of the nonprofit. Obviously, you can have reasonable compensation for the people working at the nonprofit. There are rules and guidelines around that to make sure somebody isn't kind of using that as a workaround from private inurement. But these rules don't restrict, obviously, receiving compensation that is deemed reasonable.
So the other type of 501c3 is a private foundation. So these are most typically associated with the family or a corporation. So if a very wealthy family wants to set up a 501c3 and they donate a bunch of their money to it, that's almost always going to be a private foundation. They usually are more grant making, so they don't engage in activity themselves. They're more likely to be granting out funds, but you do have operating foundations. So private foundations have all of the requirements that we just went through for public charities, but they also have more restrictions from the IRS, and specifically much more stricter self-dealing rules between foundations and their donors or other what's called disqualified persons, which are donors or senior management, and then requirements that the foundation annually distribute a portion of their assets for charitable purpose. So it's 5% of their assets they have to give out every year. And this all comes from back in, I believe it was the 60s or 70s when these rules were first put in place. The basic concern is, some really rich person, they have a bunch of money, and in order to evade paying taxes on it, they set up a nonprofit. They say they're going to do this and that charitable thing. They give a bunch of money to it. They get a deduction. The nonprofit doesn't pay tax because it's got its tax exemption. And the nonprofit just, hires the rich person's kids and nephews and nieces and pays them a bunch of money for no-show jobs. And they don't do anything charitable. That's sort of like the story that people were concerned about during the period of time when these rules were put in place. And so everything kind of restrictive about a private foundation, just think about like the underlying policy concerns there, which is, wealthy individuals or institutions sort of evading taxes and taking advantage of the charitable tax code.
All right, so next we'll just go through quickly some kind of common for-profit forms. The two basic ones, which most people are probably aware of, are corporations and limited liability companies. We'll go first through limited liability companies, which are often referred to as LLCs. These were created, I believe, in the early 90s. So effectively, it's just a much more flexible form of a for-profit, a lot less corporate formalities, and provides a lot of flexibility for founders. So they're governed by contract law, which provides, again, more optionality and flexibility than most corporate statutes. You typically, for the formation process, will have a very short one-page certificate of formation, and then you can have an operating agreement that effectively spells out via contract the governance of the company. Flexibility in terms of governance, you can have a board of managers, which would be analogous to a board of directors at a corporation. You could also just have the member of the LLC be the manager. You can kind of custom tailor aspects of corporate governance that you want to have in, which for very early stage companies, frankly, you typically have less of that. To provide optimal flexibility for operations. One of the key benefits of LLCs is their tax status. They can be, can we go to the next slide? They can be pass-through for taxation, which essentially means the profits and losses are taxed at the member level rather than at the LLC level like a corporation. But on the flip side, an LLC can elect to be taxed as a corporation, which you may say, why would you elect that? It kind of creates the likelihood of double taxation. In these hybrid structures, it can be a very effective tool when we are potentially dealing with unrelated business income tax, which creates issues for the nonprofit that's involved. And so it could be a beneficial element to the LLC to have be taxed as a corporation, but still have all the flexibility in terms of governance of an LLC. Some states do allow for kind of modifying the fiduciary duties of the LLC, which for corporations, you really don't have that option. And they're also very easy to convert from an LLC to a corporation if you need to do so in order to attract capital or attract talent and issue kind of equity incentives.
So another obviously type of for-profit that we're all familiar with is a corporation. Less flexible than LLCs, governed by statutory law. They have to have a board of directors. They have a certificate of incorporation or articles of incorporation. They're always, basically always separate taxable entities. You have C corps. You sometimes have S corps as well, though for hybrid structures, you can't have S corps. And the board has a fiduciary duty to act in the best interest of the stockholders. So corporation, there is the business judgment rule in Delaware, which probably many people are familiar with. Corporations in the traditional corporation, while the directors do have significant leeway to pursue kind of mission goals, social environmental goals, the rationale all has to be, does this benefit stockholders in the long run? And if there's a potential sale on the table, the corporation consider being sold, the board must take the highest offer on the table. And so for a hybrid structure, when you have a nonprofit involved, this brings in a couple considerations that we'll revisit later on, which is one being if a nonprofit which has a charitable mission sets up a for-profit entity and then maybe brings in outside investors or things like that, the directors of that for-profit entity have a fiduciary duty to maximize the value of the company and for all stockholders. And even if the nonprofit is a majority owner, it can't just control the company and have it only pursue charitable or kind of mission related things. It has to, the directors have that fiduciary duty to maximize value. And so because of these kind of concerns around fiduciary duties, people have started to look at alternative forms of for-profit structures, both in the hybrid context and then without. And so there's a variety of these alternative forms of for-profit structures. The benefit corporation is one, the Delaware Public Benefit Corporation is another, the California Social Purpose Corporation is a third, which we'll talk about all in a little bit more detail. But the general overriding commonality across these all of these alternative structures is modifying the fiduciary duties of the managers to allow for a for-profit corporation to pursue both profit and some other social mission, either a stated social mission or statutory prescribed, and to allow for a company to not just try to maximize profits, but to do some other kind of socially beneficial work, and entitling the managers to pursue that mission or to try to balance the mission. So benefit corporation is a lot of states have a benefit corporation. There's sort of a model statute that's available online, and a lot of states have adopted it. They have a corporate purpose to create a general public benefit. That's just as a creature statute, that's what they have. Then they can also specify specific public benefits. So providing low-income housing or housing to low-income individuals, or promoting economic development, mitigating climate change, whatever the case may be. They can effectively elect to pursue that. The fiduciary duties of directors requires them to consider a broad range of interests beyond just stockholders, including the public benefit, as well as employees, customers, etc. And benefit corporations, many states require a benefit director that just is accountable to the public benefit. There's a specific kind of legal proceeding that stakeholders can bring in order to enforce the public benefit purpose. And so that's kind of a unique aspect of benefit corporations. You'll see the next two we talk about don't really have those things. Important distinction: a B Corp is not a benefit corporation necessarily, or a Delaware Public Benefit Corporation, or anything else. B Corp is a license that B Labs will give a company if it meets certain requirements and pays the licensing fee. And so those requirements often include requirements related to the structure of the corporate structure of the business. And so these many benefit corporations are B Corps, but they're not the same thing. And so then two other kind of alternative forms of corporation are the Delaware Public Benefit Corporation, PBC, and the California Social Purpose Corporation. The Delaware PBC is probably the most common in sort of the broader sort of traditional marketplace, for lack of a better word, in terms of alternative corporate form. It's a little bit simpler, I would say, than the benefit corporation. You have to specify a public benefit in your charter. There's a fiduciary duty to balance that public benefit with promoting shareholder value, as well as considering the interests of those affected by the PBC's conduct. So in an M&A situation where we said earlier, a traditional corporation, the board has to take the highest offer on the table. In a PBC, the board can consider who is going to protect the mission the best and balance that with who is giving the highest offer. And so for that reason, many social entrepreneurs who are forming companies because they want to help solve some social problem, like the PBC form. Investors, even traditional investors, are pretty comfortable with it. And in hybrid structures, PBCs are quite useful because you can sort of link via this public benefit statement that you have to have in your charter. You can sort of link the charitable mission, the charitable purpose of the nonprofit with The PBC corporation, because there's this fiduciary duty to promote the public benefit, it's a little closer to a traditional charity than just a traditional corporation where there's no impact requirement at all. PBCs don't have benefit directors. The benefit reports are only due to shareholders. You don't have to publish them. And so some people who like the benefit corporation kind of like that greater accountability and greater transparency that they require. And the California Social Purpose Corporation, pretty similar to the PBC in a lot of respects. One key distinction is that the annual report is made public. So here's a sort of distinction between the benefit corporation and traditional corporation. We'll go through this all in detail. We already kind of discussed most of it. And you'll have the slide deck to look at this in more detail. But key is the governance, right? Different fiduciary duties. Transparency can vary when you're talking about what kind of alternative corporate form.
I don't know if there was a hand up or are you?
Yeah, we saw a hand raised. I don't know if we have the ability to.
Y'all keep moving forward and we can do Q&A at the end. You're doing great.
Okay, perfect. So the last item we'll talk on for the for-profit forms is a public benefit limited liability company. So fun acronym PBLLC. This is just a variation of the LLC that incorporates the public benefit component that Dan was talking about in terms of embedding a mission statement in your charter of your LLC and similar requirements in terms of your corporate purpose, fiduciary duties, reporting. I think the main takeaway from the PBLLC versus the PBC is it continues to have that same flexibility. So while there are certain aspects of the Delaware code that apply to the LLC, certain things like reporting, which is required for PBC, is not necessarily required for PBLLC. So essentially, this has all of the benefits of the flexibility of an LLC while also having the benefits of the public benefit corporation. So in terms of the different for-profit forms that we talked about, just kind of some high-level challenges and opportunities that we'll flag. One of which is just a lot of people are familiar with kind of the traditional corporations and LLCs. And so it's just kind of getting over that, fear of the unknown in some respects, which sounds kind of silly. But these are newer features of corporate law. The Delaware PBC was adopted in 2013. So, that's only 12 years ago. Just say in the last 5 years, the kind of familiarity from both the company side and investors has increased drastically. You have 20 plus PBCs that are publicly traded companies. But this has been, frankly, a hurdle is just people's unfamiliarity with what a PBC is. That is enhanced by the second item here, which is the lack of legal guidance. So everything we've talked through, Dan went over the balancing of fiduciary duties between maximizing profit and your public benefit. There's limited case law on how Delaware courts will adjudicate that. So while you can kind of read the statute and understand there is a balancing act, what does that mean in practice will be borne out as there is litigation, but that is, frankly, a challenge with these structures is you don't have that case law to go off of. And Dan, do you want to do the other couple?
Yeah, so the next one, just confusion over nomenclature. I already kind of hit on that. Say B Corp, what are they actually talking about? What are they referring to? People use it as a catch-all, but there are variety of important legal differences that are going to matter to you if you're a social entrepreneur, if you work at a nonprofit that's considering, setting up one of these entities, whatever your case may be, that the legal nuances might be quite important to you. And so understanding that, the distinction when people say B Corp is important. State law variation. So a lot of states, the benefit corporation legislation wasn't, elegantly tied into the broader corporate code. So there's often a lot of confusion as to like what actually applicable law says about, a variety of topics. California has both the benefit corporation or the social purpose corporation. And then finally, a lack of compliance. You see many companies that are one of these entity types. They are not doing benefit reporting at all, or if they are, it's like a marketing report effectively, where it's not actually adhering to what is required in the statutes. The board of directors has to often approve the benefit reports in the statutes. You may see many people aren't doing that, and that can be a concern from a risk perspective because it could open up a company to litigation, and then also from a sort of a credibility perspective, right? Like, is this all just greenwashing or whatever if companies aren't actually like rigorously reporting on what they're doing? So now we'll sort of switch gears. That hopefully laid the groundwork a bit for wrong direction. Laid the groundwork for the types of entities you see in hybrid structures, specifically, what we are seeing frequently with these alternative for-profit forms and hybrid structures. And now we'll actually move to more detailed discussion of hybrid structures themselves. So a pretty common hybrid structure that we see involves just a contractual relationship between a nonprofit and a for-profit entity. And so you see these in a variety of contexts. You might contract for sharing specific services and products, sharing resources, using IP at fair value or market rate, sharing IP. The key aspects that distinguish this from the other structures we'll talk about. The nonprofit doesn't have equity ownership in the for-profit. There often are not overlapping board members. There's two separate boards, two separate management pools, etc. In some respects, this can be sort of the easiest to structure from a legal perspective because you don't have as much sort of intertwining relationships as you have in some of the other ones. If there are really two separate boards and the parties are, at arm's length, and so the nonprofit is sort of not just operating for the benefit of the for-profit. They come to an agreement on what's a fair deal, what's fair value for the nonprofit's assets. That can be a kind of a pretty straightforward way to accomplish your goals you might have for a hybrid structure. As you'll see throughout the rest of the presentation, one of the kind of key issues that you have to solve for in these relationships is nonprofits. Their assets, when they use their assets or the assets leave a nonprofit, they can only be used, for their charitable purpose. Or if they are sort of selling off assets, they have to get fair market value for those assets. And so a for-profit nonprofit relationship that you have to make sure that the for-profit is paying fair market value for what it's getting from the nonprofit. You can't just give it away to the for-profit, and that's a big challenge. But there's ways to solve for that. And one being making sure you're actually charging fair market value and having a process in place where you have an arm's length negotiation between the nonprofit and the for-profit.
And one thing I'll add is just it's important, as Dan mentioned at the outset in talking about nonprofits, to kind of remember the policy rationale behind nonprofits. And so everything around making sure the nonprofit is getting fair value is to protect the fact that these are assets that have been, incubated, developed, whatever you want to say, with tax exempt dollars. And so if they were able to have that tax benefit and then, transferred off to a for-profit, those are going to raise the private benefit, private endearment issues that Dan discussed at the outset.
Yeah. And one thing also with that, and we'll get into it when we talk about like sort of common issues at the end, is, but it's worth saying multiple times, is it does not matter that the for-profit, it doesn't matter very much. It matters some. It does not matter very much if the for-profit is also like pursuing like a sort of mission or impact that is aligned with the nonprofit in some way. If the shareholders of the for-profit are seeing the value of their investment go up because the nonprofit is like giving stuff to them for free, and even if there is some argument that's mission aligned, like that can raise private benefit concerns where these tax advantaged assets are moving to an entity with shareholders, and those shareholders are seeing their investment value go up as a result of that. So one structure where that issue is less of a concern is when the existing nonprofit forms a wholly owned for-profit subsidiary. This structure can be a little simpler as well as compared to some of the other options because there are no third-party investors, there are no outside shareholders other than the nonprofit. The nonprofit can set up the for-profit entity to promote the mission of the nonprofit. Maybe there's some kind of non-charitable activities it wants to operate through the for-profit. That can all be done pretty straightforwardly. You have less of a concern about private benefit because any value that the nonprofit moves to the for-profit, because the nonprofit owns 100% of the for-profit, effectively it's still within its remit of assets it controls, and so you're not concerned about some other shareholder or someone like that getting value. Crucially, as Michael discussed, sometimes you see nonprofits set up for-profit subsidiaries as LLCs, which will make it a pass-through entity unless they check the box to be taxed as a corporation. And the reason for that is to take advantage of the flexible use of the LLC. The LLC can be sort of for accounting purposes consolidated. The issue with using that is the LLC's activities are effectively attributed to the nonprofit in terms of its charitable status. So you can't just put a bunch of non-charitable activities in an LLC that's not a taxable corporation. The IRS is going to look at that as effectively a nonprofit, and you could generate UBTI, unrelated business income tax. And so if that's a concern, you would want to set it up as a taxable corporation, as a corporation, or LLC taxed as a corporation, because a corporation effectively blocks UBTI. It'll pay income tax itself, and so the IRS isn't concerned about the nonprofit owning that entity. But you might want to use an LLC if you are going to do charitable activities in an LLC, and for whatever reason you just want to separate it from the rest of the nonprofit. Maybe you're aggregating donations into like a separate entity to do something specific, and you just want that corporate segregation. So move to the next one here. Whoops, I don't know what is going on with this PDF. Wrong direction. Okay.
So the next example we will talk about is where the nonprofit is a minority investor in the for-profit. So you can see the visual on the right-hand side. The distinction from the last slide is we now have these investors coming into the for-profit. If the nonprofit is a private foundation, there are limits on the level of ownership that it can have in a for-profit, which is 20% of the voting stock. If it's a public charity, that limitation does not apply, but you will still typically have the nonprofit holding a minority amount rather than a majority. So if you recall, there's kind of two distinct types of 501c3s. There is a distinction between the level of equity ownership that they can have in a for-profit. For the public charity where it doesn't have the 20% threshold, a reason why we typically do not see it holding, 51% is you then have a nonprofit that has control at the stockholder level of a for-profit where the board has a fiduciary duty to maximize profit, and there can just be a disconnect in those in those two governing bodies, which can create issues. A lot of the issues that Dan mentioned in the previous slides are still applicable here. They just become kind of even more acute. So there's greater difficulty to ensure alignment with the nonprofit's mission, where it holds a minority stake versus when it wholly owns the for-profit. And so ways that we try and solve for this is like any minority investor, right? You try and negotiate for certain specific governance rights. And this could be approval over the public benefit. If it's a public benefit corporation, it could be approval over certain sale transactions. There's kind of a litany of different governance rights that you can have. But again, when you're a minority holder, you just are going to have less rights. Conflicts of interest, again, still apply, and you're now going to have outside investors who, depending on what type of investors they are, may have different views than the nonprofit. So there, again, needs to be careful management to avoid any of the UBTI issues. One kind of remedial measure that we will usually have for the nonprofits is a redemption right. So they own equity in the for-profit. For whatever reason, if the for-profit kind of changes its line of business or is not as aligned with the nonprofit such that it creates an issue for the nonprofit's tax-exempt status, the nonprofit would have the right to be redeemed out of that investment. Conversely, as you can imagine, any sort of rights that are unique to the nonprofit could pose challenges for an exit for the nonprofit. And by exit, we mean, a sale to another third party. And so if the nonprofit has a block right on being able to sell the for-profit to certain types of buyers, that's going to have an impact on the valuation of the company and may, deter third-party investors from investing in the for-profit. There will oftentimes be some overlap in the directors or managers. So again, the importance of having independent directors to approve transactions between the two entities, conflicts of interest policies, and maybe special committees for good corporate governance. And then in this case, it is very rare to not have the for-profit be a corporation. A pass-through where there's outside investors typically is never really workable. So this is one instance where the kind of flexibility of the LLCs is not really an option, or at least all of the flexibilities are not an option. Okay, the next one we're going to talk about is a for-profit that establishes a nonprofit. And the kind of most standard example of this are kind of the large corporations that will form an affiliate private foundation. This graphic has the dotted lines, as you'll see, because as we mentioned at the outset, there is no actual owner of a nonprofit. And so the way control is established is through governance, where the for-profit has the ability to designate a majority of the directors of the nonprofit, or maybe it controls it through, providing all of the funding. All of these issues, again, are still applicable in terms of the need for independence. Anytime you have transactions between the two parties, you want to have independent directors who are approving those. If they're sharing resources like back office, accounting, stuff of that nature, that's completely fine. But if the for-profit is providing those services to the nonprofit can't be paying more than fair market value, right? Like Dan was alluding to earlier. And And then again, private benefit issues where the assets of the nonprofit are not being utilized by the for-profit without paying for those. So you can see there's a lot of similar issues in any of these types of structures. The outside of the first one, where if there's really no overlap in governance, contracting between the two parties is pretty straightforward. And then depending on some of the distinct characteristics, some of these issues become more acute.
And now we're going to switch gears a bit. Probably maybe the most important part of the presentation is why or why not should you use a hybrid or tandem structure, and what are kind of key issues and pitfalls to solve for, which we've been flagging throughout. But now that we've kind of gone through the universe, I think it's helpful to pull out in more specificity what those key issues we see are. So why would you want to use this structure given all some of the complexities? The benefits are a few. First of all, you can have sort of flexibility in the types of activities that you can do. You can have a nonprofit doing charitable activities, raising philanthropic capital, like the next bullet says, and then you can also have a for-profit entity that is doing non-charitable activities, maybe still mission-oriented or impact-oriented, but they're not considered charitable by the IRS, which, as we know, can have sort of a narrower view on that than maybe you or I. And so you can, in that for-profit entity, raise investment capital. You can do that kind of broader range of activities. And so, hopefully support each other in some way, as long as you're, compliant with the relevant IRS rules. If you're a for-profit entity right now and you're thinking about setting up a nonprofit, it could help increase your credibility in impact circles, or sort of if you talk to foundations about work and you work with foundations by having a nonprofit. I don't know if nonprofit arm, I might rephrase that. A nonprofit entity in your universe that engages in charitable activities. There can be some, like I said, support of each other through the nonprofit. You could have a nonprofit that does research that does benefit the for-profit. The key with that is that the nonprofit's research products should be made public. You can't just give them to the for-profit and then they go out and develop IP on top of it. But you could have a nonprofit, an environmental nonprofit that gets philanthropic funding, researches environmental issues that are relevant to a solar developer or something like that, and then makes those research results public, and that it can work in that way. And then finally, if you are a social entrepreneur and you want to start a for-profit business, but you're concerned about mission lock, making sure your mission protected, having a nonprofit entity that owns equity in your for-profit and has governance rights can help ensure that for perpetuity, your nonprofit or your for-profit has sort of a watchdog, a sentinel, to try to make sure that you're continuing to pursue your mission. Sorry.
As Dan alluded to, there's a lot of positive reasons and a lot of attractive reasons for why people kind of pursue these types of structures. There are challenges, and I think sometimes it is just due to not necessarily understanding all of the implications of using a nonprofit in a structure. One of the benefits is it can potentially allow you to pursue a broader array of capital if you have a nonprofit in your structure, because there is the ability to raise philanthropic capital. But that does not mean you just set up a nonprofit, you get donations, and then that flows through to the for-profit entity. And that may sound very basic, but that is something we often kind of have to grapple and explain to clients how the flow of funds, how the flow of resources has to work, because the nonprofit has to be operated for a charitable purpose. The assets of the nonprofit are held in charitable trust. And so it is not simply just a corporate conduit that you plug in and can, unlock all of these benefits. The benefits are there, but they have to work within the restrictions of nonprofit corporate law and just interested party transactions. And sometimes those are hard for especially founders who are essentially creating a startup to kind of deal with.
Yeah, like a nonprofit exists for its charitable purpose. It has assets that are held in charitable trust for the benefit of the public. And so this can often be hard for especially founders of nonprofits to understand because they kind of view it as their baby. So here's an example of some issues that Michael and I have both seen with clients or in the marketplace. A founder of a for-profit business, they want to form a 501c3 and she wants to sit on the board. The nonprofit's going to apply for grant funds and then buy, products from the for-profit. And again, this doesn't have to be, done in a corrupt manner. Like the nonprofit could produce, like medical devices, and then or the for-profit might produce medical devices. The nonprofit's goal might be we're going to get grant funds and then buy products from the for-profit, the medical devices, and then go give them away to people who can't afford to buy the products. That's all good. But you have to make sure that the nonprofit is paying either fair market value or less than for those products. It can't overpay for the products. That looks like to the IRS or state attorney general, like you're funneling charitable dollars to your business. Ideally, the for-profit gives away the products to the nonprofit. And so second example, a nonprofit owns a minority interest in for-profit and wants to apply for grant funds and just give it to the for-profit. That doesn't work, as Michael alluded to on his last slide, unless the nonprofit's getting something out of it. And then this last one is definitely a classic one. Some nonprofit CEO, she's worked there for a while. She wants to form a new for-profit and move cash, IP, and other charitable assets to the for-profit, which will then give equity to employees, including the CEO and maybe even investors. Again, this might come from a very reasonable concern of, hey, the industry we operate in, there's a lot of for-profits that pay way more than we can pay our employees. So as a nonprofit, we can't achieve our mission while we are subject to the nonprofit rules on, compensation or things like that. And so that might be a very, reasonable concern. But again, this is moving assets out of a charitable trust into a for-profit entity for the benefit of private individuals. The nonprofit has to have fair market value. You have to have good governance in place to ensure people without a conflict of interest are not involved in the decision making. I know we're getting closer in time.
I'll go through quickly. Structuring tips. High level. Managing of the two entities is complicated. It's costly and it's time consuming. And so, having a very well-versed CFO is often a prerequisite so that you can monitor the flow of funds and resources. Right. If you have to, determine fair market value, are you getting a valuation? Are you hiring a consultant? Are you doing market studies? There's just a lot of different pieces that go into it. So again, it's not as easy as, well, we set up this entity and we're good to go. There have to be separate functions to the entities where the nonprofit is not just solely serving as kind of a servicing arm of the for-profit. And then frankly, one that probably would seem like not that hard, but is having disinterested members of the board. Sometimes we will find the founders don't know who's going to serve in those roles, and you need that to be able to transact between the two entities.
Yeah, I think the key, is the best practice here. I think the two big key things, are these second and third bullets. If we're going to do this, is you got to have good governance. So the board, especially the nonprofit board, needs to have directors that have no financial interest in the for-profit, that only are incentivized, motivated to care about the nonprofit's interest and charitable mission. And the directors have to, know what they're doing. And then the nonprofit always has to get the benefit of a deal with the for-profit. If any assets are moving between the two, any resources, the for-profit either has to pay at least fair value or greater to the nonprofit. Vice versa, if the nonprofit is getting something from the for-profit, he needs to either get that for free or pay below market rates. And so I think we can kind of wrap up. We have 3 minutes left. Hope, I don't know if you have any questions you've seen that you want to address.
We have a whopping 9 questions. I think
Love it.
I know, right? Juicy stuff. I think we can continue to record this if you all are comfortable staying on a little bit longer. There's a lot of good material here. Do you mind if I start feeding them to you?
Sure, yeah.
Great. Okay, so the first question is from Matilda, wondering how grant funds factor into a particular distinction. I think that was earlier on in the presentation. Maybe we could try a separate one. I also want to give a shout out to our legal cafes. If anyone has specific legal questions that are not answered today, you can sign up on our website and receive a free legal consultation. Daniel is there all the time. He's a staple, perfect volunteer attorney. But yeah, okay. So we had that grants fund factor.
Yeah, I mean, I guess that can, like, grant funds, if you have an existing grant, you're going to be subject to the terms of the grant agreement. And so that'll often control how, what you can do with it, right? Or if they're thinking about like going out and getting new grants, those again, they'll have their terms. And if it's for charitable purposes, you just have to make sure that, how you're spending it is commensurate with that. The other, right, if the for-profit gets a grant, then it's a little simpler.
Thank you, Daniel. All right, this one's alphabet soup. Can PVC/SPC/PVLLCs receive tax-deductible donations?
No.
Okay. How for nonprofits, how do you determine what amount of compensation is reasonable?
Yeah, it's a good question. It's not really a legal question. It's really depends on the marketplace you're operating in and the job you're hiring for, right? And so there are accountants or compensation consultants you can hire. Unfortunately, you have to hire them that do like compensation studies. But it's like if you're hiring an executive director in San Francisco for a San Francisco nonprofit, what's reasonable for their compensation may be different from if you're hiring, a junior employee in, a city with a much lower cost of living, right? So it's usually, that. And so if you don't want to hire a compensation consultant or accountant, you kind of have to just do your best to figure out what does this job usually pay, right? The main concern is not, outrageously overpaying them, right?
Amazing. Okay, and the questions are doubling up here, so please feel free to tap out when you need to. Next question is, does the estimated 2-year delay on 501c3 IRS reviews mean that 501c3 only funding sources or grants are unavailable for those 2 years?
So if you've applied for your tax exempt status and you've not gotten it, then what you're doing is when you're going out and soliciting grants from people, you just tell them that, right? Like we've applied for 501c3, we've done our Form 1023, some foundations or grant makers are comfortable giving a grant on that basis, and some aren't, and so it's like a case by case basis. Yeah, I'm not sure. And then donations, again, you have to tell the donors the same thing. And then they can make their donation on that, after that disclosure.
Helpful. Okay,
Hi.
moving.
Hi, this
Oh,
is
Susie.
Susie. Excuse me. This is Susie, the interpreter. I have to leave, and I'm so sorry to leave you at this point.
That's okay, Susie. Thank you so
Okay.
much for joining us today. You are wonderful. We'll see you again
Oh,
soon.
thank you. Bye-bye.
All right, Daniel, next question. What are some common goals you see when groups want to form hybrid structures?
Common goals, you said? Sorry.
Yep, common
Yeah,
goals.
yeah, it's usually there is a desire, if it kind of depends on where you're coming from. Usually there's someone is starting out with, usually there's an existing nonprofit or an existing for-profit. So there's an existing nonprofit, usually the desire is you want to engage in some kind of activity that's not charitable. And so you want to house it there rather than to like risk you a bit. You need to like raise money to like do your activities or your business, and you just can't raise enough philanthropic dollars. And so you're saying, we'll form a for-profit entity and try to raise, third-party investment capital. Um, Employee issues, again, like I said, like if your industry people operate in has like real issues, getting employees and keeping them because you're competing with for-profits that can pay a lot more. Those are some pretty common reasons for a nonprofit to do something like that. Um, the reverse, if there's a for-profit and they want to set up a nonprofit, usually it's, oh, like we see a need for, there's a need in our industry, in our near our business to either, like I said, like get medical devices to people who can't afford them, or to like put solar panels on the roofs of like low income housing or something like that. We can't as a for-profit, or we could do that as a for-profit, but this is charitable activity. Let's set up a nonprofit that sort of sits next to us and can have this advantage of tax exempt status and get tax deductible donations. And then it can go out and do this stuff. And it's sort of, we have the expertise to help do it, and we're just making a difference. So that's sort of like almost like similar to like a corporate foundation or something like that, or that mission lock thing. You want to have a nonprofit in your equity structure to prevent to serve as like a sentinel. Though the nonprofit has to like do activities beyond just hold equity. Typically, like you often see people come with you who immediately want to do for-profit and nonprofit, and just my personal opinion, it's like those often are hard to get off the ground because it's just too people are trying to do too much at once. It's probably, best to start with one of the entities if you don't have either, and then kind of figure out what you're doing next.
Daniel, we have more.
I I'll give to 410. I think I gotta run at 410.
All right. How does a quote contract-based relationship, end quote, affect the public support status of a 501c3 public benefit nonprofit, to make sure that we would still pass the public support test? Is it similar to how one publicly supported nonprofit will have a status change if, quote, too much of their funding comes from a private foundation funder?
Uh, that's a great question. I don't know the answer off the top of my head if there's anything unique to that. I mean, if the nonprofit is generating revenues from the for-profit's paying the nonprofit for something, then those revenues would have to be categorized as, falling into public support or not. And I just don't, I'm not a tax attorney, more the corporate side. I don't know off the top of my head all the considerations that would lead the categorization of the revenue, but I would say it's like it's not anything special or different or unique if you were just, any other kind of revenue you get from, your programs that isn't, donations, right? And so you would just want to work with your accountant to figure out how this would be categorized.
Great. Okay, thank you. So this person's been thinking about an S corp. Is there a hybrid like benefit corporation, et cetera, that would allow them to give more weight to a public benefit that's related to the mission?
So is a question to, oh yeah, I guess this caveat about not being a tax attorney continuing to apply. I'm not aware of any reason why you couldn't have a PBC that is taxed as an S corp if it meets the S corp requirements, which I'm not familiar with. So you could have a PBC, and if it otherwise, the ownership structure complies with the S corp rules. I personally am not aware of any particular issue with that, but I would defer to a tax attorney on that. In terms of like giving more weight to the mission, um, in a PBC or SBC or benefit corporation, there's like the statutory framework of the fiduciary duties, but then there's still like significant discretion given to the management to pursue a particular course of action in the business. And so certainly if that's what, management, and if you're the only stockholder of the business, or if there's only a few other stockholders and you're all kind of aligned, there's no like reason why you can't really press the pedal to the metal on the mission side.
Okay, rapid fire, one more. We are a nonprofit 501(c)(3) that currently generates the vast majority of our funding via fee for service. Would any of these hybrid models be more or less suitable?
Um, I think I don't think that on its own would determine. It kind of depends on what you're wanting to do. If you're wanting to, you know, bring in outside investors because you're trying to expand the business or for whatever reason, um, you would, something like this, right, is something you'd be looking at. If you're just trying to house some activities in a subsidiary, if you're worried about UBTI, it doesn't sound like you are from your question, but if you were worried about UBTI, right, you could move things into a taxable corporation. Um, but yeah, I think you have options in all categories.
Well, thank you, Daniel, so much for your presentation, and thank you to your colleague as well. Everyone in attendance, we will be here for you if you need us. Daniel, feel free to log off. I'll stop recording. Have a lovely rest of
Thanks.
your day.